Hello, friends. It's another day with the Legal Breakdown, hosted by Sansone Howell Attorneys at Law and KTLV 1220 AM. As always, we like to thank our host station, KTLV 1220 AM, and remind you that you can listen to this program every Wednesday live from 5 to 5:30 p.m. on the drive home. If you're not able to listen over terrestrial radio, it is available through the TuneIn Radio app that can be downloaded for free on either iOS or the Android operating system to listen anywhere on your mobile device. In addition, we stream live the video feed on Facebook. You can look that up on our Facebook page, Sansone Howell, Sansone Howell. Maybe you're unable to listen live each week. You can always listen to every episode after the fact. It is available on youtube.com in video form or in audio form as a podcast, and that podcast can be found on all major directories, which include Apple iTunes, Google Play, and Spotify. Well, let's dig right in today. We are going to be talking about foreclosure. We're going to talk about how to protect your home. If you own a home, whether that's a traditional mortgage, whether that's a contract for deed, buyer, a seller-financed arrangement, whatever it might be, it's most likely the most important physical possession you have. That the truth is, your home, is a man's castle, and so you're going to do anything and everything you can to protect that, preserve that, save that. And the good news is, Oklahoma law feels the same way. You're given a bounty of protections to preserve your house should you ever fall on hard times. So first, we need to distinguish that there's two general categories to foreclosure. You have what's called judicial or non-judicial. A judicial foreclosure is more common. It's what most people think of. It's what most people are familiar with. A judicial foreclosure would be initiated through the courts, and so we'll go into that whole process in a minute. A non-judicial foreclosure in Oklahoma is known as a power of sale or power of sale clause. How do you know, first off, which you might be at risk of having? Well, everyone is at risk of a judicial foreclosure. Even if you have a power of sale clause in your contract, the lender could elect to use a judicial foreclosure. So if you fall behind, if you're in default, if you don't make the payments on your house, no matter what, you need to listen when we talk about judicial foreclosure. The only way non-judicial foreclosure is going to come into play or be relevant to you personally is if you agreed to that process. It would have to be in your mortgage. It would have to be in the original contract itself. And so it's very likely very conspicuous. It's clear. It's probably big, bold print, maybe underlined, italic. But it's going to say that you're giving up certain rights and protections, that you are allowing the lender to have that power of sale non-judicial foreclosure process. Now, I'm not telling you to immediately go grab all of your original loan docs you signed and look for that. But if you ever get stuck in a situation where you're potentially being foreclosed, then that is something to be mindful of. That is something to look up out of the gates. So I want to go into non-judicial foreclosure first because, unfortunately, it's a lot shorter and easier to explain because you have less rights and protections. And then we're going to go into judicial foreclosure, and we're going to bring them back together, and we're going to discuss what you can do to try to protect yourself, what some of those different options are. So non-judicial foreclosure, power of sale, number one, is not subject to the Fair Debt Collection Practices Act. And I can say that with a great degree of certainty only because the United States Supreme Court actually ruled just last week on this particular issue. Obdusky, we talked about it on our show last week. It's a relatively landmark ruling. 9-0 from the United States Supreme Court. But Fair Debt Collection Practices Act, FDCPA protections are not going to apply in a non-judicial foreclosure. So be aware of that. You're not going to have those to protect you. But if you have this power of sale clause in your contract, then the lender does not have to go to court to take possession back of and sell your house. They can follow certain procedures. Those are laid out in the Oklahoma statutes, and they're probably also going to be listed in your mortgage. So what are some of those processes? First, they're going to give you a written notice of their intention to exercise the power of sale clause. It's going to specify the time, the place, and the terms of the sale that they intend to do. And it's going to give you at least 35 days from the date of the notice to cure your default. What does cure your default means? It means that you'll have 35 days to get caught current, to pay up any past mortgage, any arrearage, to make whole on that contract. If you don't do that in the 35 days, they can continue. If you do it, then that temporary foreclosure process will be stopped. However, if this is the third time that the lender has exercised their power of sale clause, then they don't need to send another notice or their intent to foreclose, and they can proceed without that process. But so they're going to record the notice in the county where the property is located within 10 days after they've gone through the 35-day notice period. They're going to publish it in a newspaper where it's located in the county for up to 4 weeks, and the publishing not less than 30 days before the sale. The notice of the sale must state the names of the borrowers and lenders, describe the property, including the address, and state the time and place of the sale. The property would then be sold at a public auction to the highest bidder. We can't game the system and say, well, we're just going to have a few people show up so that the buyer or the lender can sell it to themselves, low ball offer, something like that. It has to be a regular public auction, has to go to the highest bidder. And if the sale must post cash or certified funds up to at least 10% of the bid amount. If the highest bidder is unable to do so, then they proceed with the sale to the next highest bidder. But at that point, you can tell that's a relatively short process. That's not long. It doesn't give you a whole lot of powers and protections as an individual. The lender will have sold the home. They will have recovered their monies under the lien, and you will no longer have that house, that property. So we unfortunately don't have tons to talk about in non-judicial foreclosure because it is so quick, it is so short. This is why it's not very common. Most major lenders, if you will, your institutional lenders, Wells Fargo, JP Morgan, Chase, Arvest, Bank of Oklahoma, you don't typically see this in their contracts or clauses. And even when they have these clauses, they're more likely to exercise a judicial foreclosure. But so be aware, where we see this the most are when we have owner-financed contracts or contracts for deeds. Usually it's with less sophisticated parties or parties that are not institutional lenders. So look out for that. Now let's talk about judicial foreclosure. And I want to remind everyone, by the way, haven't got any calls today. We've gotten a few questions that we've tried to touch on through our social media, but this program is designed to be interactive, that if you have a question, if you have a concern, maybe you're going through this type of situation right now, feel free to give me a call, 405-347-7238. That's the line for our phone number. It comes right into me, or you can pose your questions online through social media on our Facebook Live page, and we can see those, and we will try to answer those. Also, just to segue and touch on, we recognize that the Facebook Live feed has had issues over the last couple of episodes. We've had a lot of technical issues with our internet provider, Cox Communications. The bad news is we're still having those issues today from the looks of it, and so this feed may cut in and cut out. It may buffer, it may stutter. I apologize. We're doing what we can. The good news is we have a contract to get a new fiber optic internet connection. Should be rock solid, no downtime, no latency, and that's going to be installed very soon so that we won't have these kinds of problems, so that everyone can see these videos or listen to us the way they are meant to be delivered. So just wanted to give that good and bad news to our viewers and listeners today. But so now, judicial foreclosure for the final two-thirds of the program. A judicial foreclosure is going to begin the same way that any other civil litigation lawsuit would start in the state of Oklahoma. That the plaintiff, the lender, is going to file in the county a petition and a summons, and they're then going to serve that on the defendant, who in this case is very likely you, the homeowner. The clock doesn't start until you are served. If you haven't been successfully served, we don't have a timeline yet. Once you are served with that, you are now on the clock. In civil litigation in Oklahoma, you have 20 days from the initial date of service to file some type of responsive pleading. You could file a motion to dismiss, you could file a reservation of time, or you could file an answer. What are those different things? Well, an answer is where we respond to the petition. We're going to say we agree or we disagree, that we deny certain statements, maybe we concede certain statements, depends on the circumstances. And you're going to also raise affirmative objection or affirmative defenses. An entry of appearance and a reservation of time is a very powerful tool. It can be exercised by an attorney or a non-attorney. And what that does is it gives you an additional 20 days to respond. So we went from 20 to 40 off the initial. But it's not all cake and eat it too. Be very aware that in doing that, you can waive certain defenses that you otherwise had if you had raised them initially within the first 20 days in an answer or in a motion to dismiss. So be aware of that. And then the last would be a motion. In the normal pleadings practice of initial petition, if you file an answer, you then have waived, as sort of similar to that entry of appearance, certain rights and protections. And so if there are things that need to be raised out of the gates, you have to do that with a motion. After that motion is resolved and the court enters an order, then they would enter a time period to file an answer after that. So it depends on the circumstances, depends on the complexity of the case, depends on whether or not you're attempting to do this pro se on your own or whether it's through counsel. But one way or another, what's critical is that you do follow the timelines and that once you are served, you notice and you're aware that in that summons it says you must respond in 20 days, because if you don't, you're going to be in default. You don't want to be in default in virtually any type of lawsuit, because once you're in default, meaning you haven't answered within the time period prescribed, then the party that has asked for certain relief, the plaintiff, can obtain that relief at any point without providing you any further notice or without having to take further action. They can obtain a default judgment. That would be, in essence, game over. You don't get to argue anymore. You don't get to try to sort out the case. Someone sued you, you disagree with the amount they're suing you for. Well, you want to make sure you preserve your interests. You don't let it go to a default judgment. And like I said, if it goes to a default judgment, now we have less options. The only options would be to try to have that vacated or potentially under certain grounds maybe appealed, but usually vacated. Also important, because we're going to end up talking about bankruptcy here in a moment, there's what's known as the Rooker-Feldman Doctrine. Now, good news, I know this is a whole lot of information, and there's not going to be a quiz at the end of today's show. But what that says is that a federal court doesn't get to revisit, they don't get to relitigate issues that were determined in a lower state court. So if your foreclosure has a judgment entered, whether that is by summary judgment, whether it's a judgment at trial on the merits, whether it's a default judgment, you can't come back later in a federal court like a bankruptcy court and try to change the order that was entered by the state court. So let's say that they grant a large amount of attorney's fees as part of this foreclosure process. You didn't even object, you didn't respond. They get a default judgment, and the plaintiff, I'm going to pick on Wells Fargo, says we would like $2,500 in attorney's fees for putting together these papers. And the judge enters that order and they say, yes, you get $2,500 in attorney's fees, even though there was really no litigation in this case. It was a default. When you're in bankruptcy, like a Chapter 13, and you now decide, I don't want to have to pay that extra $2,500, I think that's absurd. Why was that awarded? You're not going to be able to revisit that issue. Rooker-Feldman's going to stop you from arguing that as part of any objection to claim or defense in the bankruptcy court. So I note that so that everyone realizes that that time period for judgment can be very important. We want to make sure we keep the case alive, or maybe we exercise our rights to bankruptcy before that. But the case is going to be filed. You're going to be served in a judicial foreclosure. You will have done something, whether that's an entry of appearance and then an answer, whether that's an entry of appearance, a motion to dismiss, an answer, whatever it might be. You're going to exhaust those remedies. At that point, you're in what's called discovery. And again, this is the same pattern for virtually any other civil litigation case. In discovery, the parties have the opportunity to take depositions of the other side. They can ask for production of documents. They can ask for answers to questions. Those are called interrogatories. We can ask for certain admissions, requests for admission, where you're saying yes or no to certain statements. But the goal, the scope of discovery, is to learn information to build your case or defend your case. It's quite possible that during that stage, one party will file what's known as a motion for summary judgment. And a motion for summary judgment says that if you look at the facts of the case in the light most favorable to the non-moving party, which is a mouthful, then the case should still be won. So what that means is, if the plaintiff, Wells Fargo, asks for motion for summary judgment, they're going to say, Judge, based on the facts in front of us, even if we look at everything most favorable to the homeowner, to the defendant, as a matter of law, there's nothing else left for us to do. We don't need to go forward. We don't need to have a trial. We still win. And that comes up in a good bit of litigation. And the honest truth is that there is a very strong chance that a mortgage lender will file and prevail on a motion for summary judgment in a foreclosure case. Because most of the time, now that it has been more than 10 years since the foreclosure crisis in the United States, there are not a whole lot of defenses. Not always. There are obviously reasons to explore what your options are. But if it is simply, I signed a contract, I borrowed the money, I bought the home, I didn't repay the money under the terms of the contract, I admit I'm in default, I've breached the agreement, then the lender will win, and they will win on that motion for summary judgment. So at that point, there would be a judgment, whether it's default, whether it's by summary judgment, whether it's a trial on the merits, as we discussed. Now we've reached judgment. Okay. Again, at any point in time here, we could have availed ourselves of Chapter 13, and we'll talk about Chapter 13, but we're going to keep talking about the foreclosure process because it's important to understand it's not over. You haven't lost your house yet. The next step is going to be an appraisal. Oklahoma law is going to require the lender to have the value of the home appraised. It must sell ultimately for at least 2/3 of that appraisal value, and that's an important number we're going to come back to. After that, after we have the appraisal, we'll then publish a notice of when there's a sheriff's sale, and they will hold a sheriff's sale, that being the time and place of when there will be the auction to sell the home. And as already mentioned, it must sell for at least 2/3 of the appraisal value. After that sale is completed, there will be a confirmation hearing on the sheriff's sale. That's the very final drop-dead date. That is when, if you haven't done anything before now, last-ditch resort, you better, because that is when, very unfortunately, in a judicial foreclosure, the deed will physically transfer from you to the buyer, when you will lose your home and when you can then be thrown out and be evicted. So how long does all this take? Well, unfortunately, like a lot of things in the law, the answer is that depends. That depends on what you do to protect your rights. That depends on how long it takes to litigate. It could be over if you do nothing and it goes to default in a matter of months, 3 to 4. I wouldn't make it much shorter than that because of the process of service of process, minimum 20 days to respond, obtain a default judgment, have an appraisal, set it for sheriff's sale, give notice and publication, have a sheriff's sale and confirmation on the sheriff's sale is probably still going to take, at a minimum, no matter how fast and aggressive the lender is, about 3 months. It could take 2 years. It could take more. I've seen cases take a very, very long time depending on the issues in that particular case. But regardless, as we've talked about, throughout this process, you're going to be looking at your finances. Am I able to get caught up? Am I able to pay the lender what they're asking? Can I not? What can I do to save my home? Well, barring bankruptcy protection, not talking about that, your options would be to work it out with the lender. Or, alternatively, you may have certain federal law protections. And so that's called loss mitigation. And the lender has to offer you those at various stages. We're not going to get into every one of the details and nuances of what they are and if they have to offer it, but you may have heard of things like loan modifications, other details. You want to make sure that you've gone through every process available for loss mitigation and checked that they've offered that or that you've gone through it. Now, be aware that is not an infinite, limitless opportunity. So, for example, if you went through loss mitigation, they offered and you did a loan modification, and then you breached that, meaning you defaulted again through non-payment at any point in time, they do not have to give you another loan modification within a certain time period. So you can't, in 2016, have a modification, in 2017 fall behind, and then hope that you have another loan mod. So just be aware that at some point there may be difficulties. Regardless of what those difficulties are, I encourage you, like I said, to either on your own keep the case alive and protect yourself, or speak to competent counsel. The last thing anyone wants is to lose their home, and we always want to make sure that we have maximized every one of those possible protections. But as a very last sort of resort option, we're going to talk about something we've talked about on this show before, and that is Chapter 13 bankruptcy. Chapter 13 bankruptcy is a form of reorganization. It does not mean we're going to end up ultimately repaying all of our debts. So maybe you're behind on the house, but you also have $30,000 in credit card debt. It doesn't mean that if you do the Chapter 13, you're guaranteed to have to repay the $30,000 in credit card debt. It does mean, though, that if you are behind on the house at the time you filed the bankruptcy, which is presumed since we are talking about foreclosure, that would be part of the case. It must be what we call in plan. So the whole arrearage is going to be the balance of how much you're behind, the cure balance. That's going to be in the case, as well as the ongoing mortgage. And now that's a really important thing for us to pause there and talk about, because how big that arrearage is can sometimes affect whether or not the plan is feasible. And feasible meaning that in the eyes of the law, on paper, it's ever going to be affordable. Or even if you ignore paper and the law, in reality, it's affordable. Because unfortunately, it's possible sometimes for that arrearage to grow so large that no matter how long we try to stretch it out or what we try to do, we can't dig back out of that hole. The longest a Chapter 13 plan can be is 5 years. That's 60 months. So if you have an arrearage of $60,000 and the only thing we're paying in the bankruptcy is the mortgage ongoing and the arrearage, you don't have car payments, you don't have back taxes, you don't have ongoing child support, you don't have back child support, we don't have to pay anything to unsecured creditors, all those things else that could exist. Let's pretend we have none of that. Consider that's going to be $1,000 a month, math, plus the mortgage. Now I said $60,000. What if it's $30,000? Well, that's an extra $500 a month plus the ongoing mortgage. So if you're $30,000 in arrears and your ongoing mortgage is normally $1,000 and you were not able to afford the $1,000 before, you can see where quickly we're saying that Chapter 13 is going to make it $1,500. That's not going to be incredibly helpful, which leads to a very unfortunate but hard truth about bankruptcy that we have also mentioned before. The bankruptcy code is not designed to help people live outside their means. It is designed to help us address past debt. So let's say that your foreclosure has come about because you had a gap of employment or you had a temporary reduction in your income. Then Chapter 13 is a good tool to help you get back on track, to reorganize, and to save your home. However, if you have lost a job and you are still out of work, or you've had a permanent reduction in your income that's quite sizable, such that what was affordable before is no longer affordable now, then the reality may be that no amount of reorganizing or bankruptcy protections is going to enable us to save this particular house. Now, these are very fact-specific questions. We look at these on a case-by-case basis. But I'd be remiss if I didn't point out the good with the bad, that we have to be blunt and we have to mention that if you made $100,000 before and you bought a home and you could afford it, and now you're unemployed, or maybe you make, say, $50,000 a year, clearly the numbers aren't going to be the same. And so that is a key point. Also, as we already mentioned, whether or not we can then argue in the bankruptcy about how much you owe is going to be important for what your attorney could do for you in a Chapter 13. So if the judgment has already happened, if we are post-judgment, maybe we're filing the Chapter 13 at the last minute, right before confirmation on the sheriff's sale, then pretty much the numbers are the numbers. And so if they have added a lot, if Wells Fargo successfully padded their pockets with attorney's fees and court costs and all these other things, it's a done deal. I can't argue about that in the bankruptcy court because of the Rooker-Feldman doctrine we touched on. However, if you file that Chapter 13 before a judgment, and again, that could be a default judgment, a judgment as a result of summary judgment, or maybe a judgment all the way at a trial on the merits, however it comes about, you're going to have extra powers in the bankruptcy case to fight over the proof of claim that the mortgage lender would file. And if they ask for things that seem inappropriate or large, you get a chance to make them prove that up. So you might be able to get the number back down out of the stratosphere, down to earth where it belongs. So let's sum things up. We've got 3 minutes left in our show, and we have covered an incredibly large amount of information. Number one, there's two types of foreclosures in Oklahoma, and that's broadly true for really the rest of the country as well: judicial and non-judicial. Everybody is at risk or subject to judicial. The only people that are at risk of non-judicial foreclosure are those that have those terms very clear, very explicit in their contracts. With either of these, you want to stay on top of the process. You want to know your rights. You want to pay attention to any letters you get mailed or served or notice you received, because those deadlines will be critical and lenders are very likely to follow them very aggressively. With either of these processes, whether it's a power of sale non-judicial foreclosure or whether it's a judicial foreclosure, at any time until it's game over, you could protect yourself through the filing of a Chapter 13 bankruptcy to try to use that to cure the default and to get caught up on the mortgage so you save your home. You would want to speak to a very experienced, qualified bankruptcy attorney in that regard. In a judicial foreclosure, the process is going to take the same time and path as virtually any other civil litigation up through judgment, and then after that, it's going to have extra steps after the judgment so that there can be an appraisal and then a sheriff's sale and a confirmation on the sheriff's sale. The one final thing I want to touch on in our closing minutes that we didn't touch on earlier and I skipped is what's known as a deficiency judgment. A deficiency judgment is if the house is upside down. So if you have a house that has a fair market value of $150,000 and you owe $100,000, but therefore it appraises at $150,000 and could sell for 2/3 value of $100,000, and it does sell for $100,000, there's a chance that with attorney's fees and court costs, where you thought you had equity, you're now upside down. Well, can they come after you for that difference? If $10,000 was remaining unpaid to Wells Fargo, what could they do about that? Well, in Oklahoma, they must follow a very tight, very quick process after the sheriff's sale in order to obtain that deficiency. And they could. In that case, you'd either have to pay that or theoretically bankrupt out of it. However, if they do not do that in the prescribed time period after the process, they can never come back and do it. And typically it's not done. So I say that so that everyone knows on a parting note that even if a house sells upside down, major underwater, it does not guarantee that you need to file a bankruptcy because they may not have obtained a deficiency judgment and you may be safe from that particular issue down the road. Friends, this is a complex issue. There's a whole lot of things. I hope that you've learned a lot because I want you to be able to protect your house and I want you to save your home under any circumstances. If you find yourself in a situation, though, where you are overwhelmed, you don't understand the process, call an attorney or call us. As always, this has been the Legal Breakdown with Jason Sansone. Have a wonderful week, and we will see you next week.